This week on Inside Olympia, we sit down for the full hour with Chief Justice Stephen Gonzalez of the Washington Supreme Court. How has COVID affected court operations across the state? How is the Supreme Court working to expand access to justice and address racial inequities? And what are the Chief Justice's priorities for the court?
From the TBW studio, it's Inside Olympia with host Austin Jenkins.
And welcome to Inside Olympia. Earlier this year, Stephen Gonzalez became the Chief Justice of the Washington Supreme Court. It was a historic moment. Gonzalez is Latino, and he's the first Chief Justice of color to lead Washington's highest court. Since becoming Chief Justice, he has emphasized a commitment to eradicating bias in the justice system. It's an issue the entire Supreme Court addressed in an open letter in June of 2020 following the murder of George Floyd in Minneapolis. In that letter, the justices wrote, in part, "Our institutions remain affected by the vestiges of slavery, Jim Crow laws that were never dismantled, and racist court decisions that were never disavowed." Recently, a task force on race and justice presented its findings to the Supreme Court on unequal treatment in Washington's criminal justice system. At the same time, the 2021 legislature made historic investments in Washington's judicial branch and passed a number of significant reform measures dealing with topics such as legal financial obligations and drug possession. That latter in response to a Supreme Court decision that found Washington's simple drug possession law unconstitutional. Joining me now and for the full hour to talk about these and other issues and the state of the Supreme Court and the judiciary more broadly is Chief Justice Stephen Gonzalez. Welcome to the program. Nice to see you.
Thank you, Austin. Glad to be here.
Let me go back in time and start with this open letter in June of 2020. It was signed by all members of the state Supreme Court. You were not the Chief Justice yet. Help us understand what led to this and how precedented or unprecedented it was for the court to issue an open letter in this fashion.
Well, at that time, Justice Stevens was our chief, and she felt, as did some other courts across the nation, we weren't the only one to issue such an open letter, that it was important to address issues that affect the very administration of justice. And that's recognizing our past and our commitment to do better in the future. We thought that by issuing a strong letter stating what our values are and the principles underpinning our justice system, that stating that directly would empower the trial courts to consider these issues and also act affirmatively. Because as you know, Austin, the judicial branch doesn't just hear cases. In the role of hearing cases, we are reactive. So we don't choose what cases get filed in the trial courts or what issues are raised to us in the petitions for review. So we react to those as litigants bring them to us. But on the other side, we're responsible for administering a co-equal branch of government. And in that role, we have the function of passing the rules that govern the way the court works. We also have an important role in convening the discussion about these important topics. And if there is a problem in the system with how we decide on bail and release issues, with how we sentence, it's our responsibility to bring everybody together to discuss it, not based on rhetoric or a knee-jerk reaction, but on data with careful analysis and decisions. And so it was a call really to the entire legal system, the judicial branch in particular, to come together and discuss these important issues that have been raised to the forefront and make sure that we're doing our best to eradicate bias. None of us want bias to influence how cases are decided, how people are sentenced, what verdicts are rendered, et cetera.
I believe that you were a participant in a 2010 task force that looked at access to justice and perhaps even racial bias in the justice system. And then, of course, 2020 really was a catalyst moment around these topics nationally. Can you just compare 2010 to 2020 and what had or had not changed and sort of what the hope, when you wrote that letter, what it might, lead to going forward?
Yeah, well, you're bringing us back almost a dozen years now to the formation of the Race in the Criminal Justice System Task Force. And that was an effort undertaken by the minority bar associations in the state, the Access to Justice Board, which I chaired at the time, The Korematsu Center at Seattle University Law School, led in part by Professor Robert Chang, and now Superior Court Judge Nicole Gaines Phelps, who was then the head of the Loren Miller Bar Association. It was in reaction to things that were said by then sitting justices, which were troubling. And so we decided to form a group that would compile the best data that we had, identify gaps in data about disproportionality in the justice system, and then make recommendations for any reforms that we concluded might be appropriate based on that research and that study. And we came together and presented our results to the Supreme Court. Then Chief Justice Barbara Madsen invited us to present to the entire court, which we did. And that report led to the Minority and Justice Commission taking up some of our recommendations and following through on recommended reforms in the areas of juvenile justice, legal financial obligation, and a number of other issues. And recently, that group, of course, I'm no longer one of the leaders of that group now that I'm on the Supreme Court, but that group came back together to do a redo, and they called it the Race and the Justice System Task Force 2.0. And they just presented to us, I think it was September 29th of this year, their updated research. They've yet to compile their ultimate recommendations that they derive from that research, and we expect those in the coming months or sometime next year. And again, we'll probably refer those to the Minority and Justice Commission, to the Gender and Justice Commission, the Interpreter Commission, and our commission that deals with juvenile issues and family and guardianship issues, and to the Access to Justice Board, to get to work on those recommendations to try to make reforms that will bring us closer to the promise of this nation, which is that we're all equal before the law.
You know, it strikes me that it's one thing to seize a moment, and it's very much to lead or participate or sustain a movement. And in the last 12 to 18 months, I have often had conversations with, in particular, members of color of the legislature who have said this is not a moment, this is a movement. So as you think about how this movement applies to the judiciary and your branch of government and needs to be sustained for real change to happen, how do you see that happening? Where there's not just sort of a spin up of energy and effort in the moment, but then it dissipates and people kind of go back to business as usual.
You ask an excellent question, Austin, and you can see behind me to my right a bookshelf full of volumes of decisions of this court going back to when we were a territory and we had a territorial Supreme Court. So you point to a moment in time. Wherever we are at a moment in time, but we can use the metaphor of something that's on a loom that's being woven as we work. And we can look to the patterns before us and try to predict what we're going to do in the future, but we get to change that pattern as we weave, to bring in new threads and new colors and new patterns. And that's what we're doing. It's all a continuum, and I want us to have a broader view of what's happening here. And we've made some real systemic change, recognizing some of the problems that we face. One example that I'll bring forward is on jury selection and the use of peremptory challenges, which is a challenge that can be used by either side without stating a reason for removing a potential juror from the prospect of being on the final jury that decides a case. And years ago in Kentucky versus Batson, our US Supreme Court set up a framework for how to try to reduce bias in jury selection. It is uniformly recognized as failing to actually accomplish that task. And since we know that you have a right to serve and not to be removed for a discriminatory reason, and we also know that heterogeneous juries make better decisions than homogeneous juries, we thought it was important to take that a step further and ensure that we're respecting the people that we summon in to be potential jurors, and that we're ensuring that bias doesn't influence who is removed and who is retained. So we passed a court rule. Earlier, I mentioned that we have really two functions: the reactive function to cases and the proactive function to administer the judicial branch. So we passed a new rule that changes the dynamic and says you can't remove a juror if an objective observer could conclude that race was a factor in your attempt to remove that juror. The result, anecdotally so far, because the final studies aren't in, is that it hasn't disrupted the process. It's resulted in more diverse juries and a more open and searching inquiry into how we're administering our justice system and how race has played a factor in who ultimately serves. We recognize too that it's not just a matter of how we eliminate those who show up, but making sure that we get a broader cross-section of society responding to the summons in the first place. And as you may know, we pay jurors, the state pays jurors at a minimum of $10 a day for jury service. That amount that was set for jury service was set before you or I were born. And at the time it was set, minimum wage was $1 an hour, so, or under $1 an hour. So it was at least minimum wage. We all know that $10 a day is nowhere close to minimum wage now. And I think that's a factor because what I found in my 10 years as a trial court judge is we'd often get to the point of undue hardship. And for people whose employers didn't give them paid time off, they couldn't afford to be on a trial that would last a week or 2 weeks because they wouldn't be able to pay their bills and meet their obligations. And I think if we're paying at least a minimum wage, we may be able to keep more of our diverse jurors. And when I say diverse, I don't just mean race, I'm referring to socioeconomic status. And I think it's important that the jury really be comprised of all members of our society.
Yeah. For some people, if they take jury duty, it's they're still getting paid from their job, and there's no real penalty to do it. For others, it's a huge disruption, and perhaps they're not going to make their rent or their mortgage that month because they did it.
I think that's right. And as a result, it means that our juries have skewed towards wealthy folks or folks who are hired by companies that pay them for that leave, or folks who are retired. And I think we need to make sure we're more inclusive. I don't mean to say anything negative about those demographics. I just think we want all demographics represented.
You have used an interesting image to talk about the work of attorneys and the judiciary in a time of change. And you said that the very nature of the law is that you look backwards to look forward. You look to case law and you look to precedent. And I'm curious to hear you speak about how you want your colleagues in the judiciary, as they're thinking about creating greater access to justice and addressing issues of racial equity, to the extent to which the way that lawyers approach things is a strength or a weakness, or does there need to be a pivot here? Because I thought that was a really interesting image.
Oh, well, that's a challenging question, Austin. I use the metaphor of us walking through the forest backwards, looking at the stumps and the trees and trying to predict what we might trip over next. And while it may give us some idea, every now and then, I think you need to peek over your shoulder and see what's ahead. I don't mean to say that the past doesn't matter. It is critical to us. And I've referenced these books. They bring us principles that we can apply still. They are to be respected to the extent that we can. But I also want us not to be afraid from time to time to say, when that decision was made, there was a different norm. We presume the norm to be neutral, but sometimes with further insight and development, we realize that that norm was not neutral, that in fact there was a bias that influenced those prior decisions. And we shouldn't be afraid to examine those respectfully and to recognize that we only overturn precedent if we find that it's two things, both incorrect and harmful. And so if it's just incorrect, that might not be enough. If it's just harmful, that might not be enough. It needs to be both for us to overturn it. There's a third way that we overturn precedent, and that is if the underpinnings that undergirded that previous decision have changed, so that the reasons that led to that decision no longer exist. In that instance, too, we might revisit precedent. And so we need to do so carefully, but at the same time acknowledging that things change, topography changes. You walk backwards long enough and you leave the forest to the flatland, or you approach the ocean. So we need to recognize where we are at a given time and make sure that we're being responsive to it while we still respect the past.
Well, and to that end, and sort of moving along chronologically here, the open letter came out in June of 2020, and then later in that same year, the court did something that I don't recall having seen before, and you can correct me if I'm wrong, but over the course of the latter half of 2020, the Supreme Court took steps to reverse historic decisions of predecessors who had served in these positions as Supreme Court justices. One had to do with criminal charges against a member of the Yakima Nation in a fishing case where he was fishing apparently outside traditional tribal fishing grounds, allegedly. And then the other had to do with cemeteries, and I think in particular Seattle Cemetery not allowing the burial of the 3-year-old son of apparently a Seattle police officer, and I believe that this was a black family. Help us understand these cases and the decision on the part of the court to go back in and say this was wrong, this was racist, we need to correct the record.
Yeah, well, there's a lot there in what you've just asked. And so I'll take those two cases that you mentioned. The first one, the Towson case, had to do with a member of the Yakima Nation who was charged with a fishing violation. Part of the real problematic part of that case was the disparaging way that the justices described our indigenous neighbors, the sovereign nations, and essentially said that their treaties didn't need to be respected if they predated us becoming a state, and that statehood nullified those treaties. So it was both incorrect on the law and very unfortunate, frankly, racist language in the opinion. Well, we wouldn't just go out of our way to reach back and reverse it. What we had before us was a petition from the descendants of Mr. Towson asking the court to hear that case. We also had the Attorney General joining that petition. So we had a live request for us to reopen and revisit that case. So it wasn't something we just did on our own. We responded to that petition, and we recognized that there were clear errors there. Those decisions are still on the books, and they're precedent that could be cited until we say otherwise. So we thought it was important to answer that petition, to disavow both that language and the incorrect holding in that prior decision, still published on the books. Some have said that it's inappropriate for us to be criticizing with a lens of our current norms those decisions that were made years ago, criticizing justices for their language when they're no longer alive to defend themselves. My response to that would be that these books, these decisions, they belong to all of us, and we inherit them, and those who currently occupy the 9 positions on the Supreme Court are responsible for that language, for saying whether it's correct and what is or is not still precedent that can be cited. So we issued an opinion based on that petition saying that the treaties are to be respected, that they have the force of law and they are part of the supreme law of the land, and that the charge against this person was also incorrect. So we overturned that precedent. The second case that you cite, the one about the cemetery refusing to allow a Black infant who had died to be buried next to white infants. That case came up because we were dealing with a case that had to do with initiatives and the ability to include 2 subjects in one law. And not only was that case another example of justices using disparaging language, and there they were disparaging civil rights leaders and African Americans in language that is repugnant to us now. But not only that, so not only was it harmful in that way, but they were wrong about their analysis of the 2 subject in one title rule. So it was relevant to the case, and we said they're wrong on the law, and by the way, that language is inappropriate, and we disavow that sort of anti-Black language in a published opinion from the Supreme Court. So both of those examples I've given you are examples of cases in the past that were both incorrect and harmful. And so I think it's our job to say so when they come before us as part of a controversy properly before the court.
Do I recall that in that second case, one of the ways you addressed this was just in a footnote in the opinion on the...
Yes, I was the author of the case that overturned that cemetery case, as you've referred to it. And I did it in a footnote where it was relevant in the opinion. I dropped down and said, by the way, we're not applying this analysis from this previous case. It was incorrect, which means now that that's no longer precedent that can be cited for that rule because it was wrong. And I thought it was important to point out not only were they wrong on the law, but the language that they used is a language that should never be in a published opinion from this court.
I think this begs the question, can we expect more of this from this court? Can we expect more past decisions to get a second look and perhaps be reversed or disavowed? Or if there was racist language in the decisions, that the court will call that, this court will call that out?
Well, thank you for that question, Austin, but I think you've just described the very nature of our job. Our job is to decide cases on issues that haven't yet been decided and to revisit previous cases if the parties have asked us to. And sometimes when we revisit them, we affirm them and say, no, we agree that was right, or it was only incorrect or only harmful, and not both. And so our very job is to bring the facts of a recent case and apply prior precedent to them and decide whether to follow or change that course. So what you can expect is for us to review carefully the petitions that come before the court. And if those issues come up, and if we find another case where similarly they're both incorrect and harmful, then yes, we will make that decision when the case is before us.
Okay. Moving along with our timeline, I want to bring you now to 2021, when there was a internal competition or race for Chief Justice. Deborah Stevens, Justice Stevens, who I mentioned in 2020 was the Chief Justice, and she had been, I think, appointed to that position because of a change on the court. I'm curious to know why you decided to run for the Chief Justice position, and what was your platform? What was your reason for wanting to take that leadership position?
Well, Justice Fairhurst had been our chief, and our chiefs are elected to 4-year terms, and they're elected by the 9 of us. So Justice Fairhurst was serving, and she retired. And when she retired, she was 3 years into a 4-year term. So we had a special election, and we elected Justice Stevens to serve the remainder of that unexpired term of Justice Fairhurst, which she did. And when it came up again at the end of that 4-year term for an election, a number of my colleagues encouraged me to put my name in. And we are democratic here. We voted. And after I was encouraged to run and did, I was elected and began serving in January. So it was at the prompting and encouragement of my colleagues that I ran. As to why, I've been on this court now for 10 years. I was a trial judge in King County Superior Court for 10 years before that. So I've been a judicial officer for 20 years now. And I served in federal court, in municipal court, and in private practice before that. And I've been active in a variety of committees, such as the Access to Justice Board, while I was a Superior Court judge, on the Interpreter Commission here, on our Security Committee, chairing that, our Technology Committee, chairing that, et cetera. And I felt that I knew enough at that point, have enough experience at this point, to serve as chief here. So I ran one, and here I am in this role that makes me speak a lot more publicly. It gives me the privilege of being here with you this morning and speaking on behalf of the whole court, not just myself. I'm very proud of this court. We have made great strides to improve access to justice and the judicial system. And I hope transparency about the way we're going about it, by describing what we're doing, by sharing the results of what we're doing, by being here with you on this program, and by being open to visit schools, community events, and to really talk about why civics matter, why the judicial branch matters. And so I'm proud of our court, as I said. I'm pleased to lead a group of 9 independent, strong-willed folks as we debate the very difficult and important issues that come before the court.
And when you think about this role as Chief Justice and the change that you may be able to make or to encourage, what is that change? What is you've given us some specific examples already about, for instance, jury service. And we've talked about terms like access to justice, and I referenced in the introduction that you had said when you were sworn in as Chief Justice that you wanted to follow through with the commitment to eradicate bias in the justice system. And you said not just to point it out and recognize it, but to come up with actual solutions. Kind of big picture here, 30,000-foot view. Where are you trying to steer the court and more broadly the judiciary as Chief Justice?
Yeah, well, I appreciate your belief that I have the ability to steer this group of 9. We vote by majority, and so the role of the chief really is just to convene the discussion, to moderate the discussion, to make sure everyone is heard, and then to implement the vote of the majority of the court. So it isn't my agenda, it's our agenda that I hope to further. Personally, it's very important to me that we issue our opinions in a timely manner, that the opinions are understandable not just to judges and lawyers, but to the lay reader who reads our opinion. At least the opening paragraph and the conclusion should be that understandable and accessible. So I want us to do that. I also want us to examine ourselves closely and to live up to that letter that you referenced that we issued a year and a half ago, and to rise to that challenge and to examine carefully what we're doing. I hope we're doing that. I think the Gender and Justice Commission study that just came out is a tremendous step in that regard. And if I could just mention a few things that study found, because they align with what I think our court wants to accomplish. The study found that gender and race combined still affect outcomes in cases, in courts, and access to justice here. And if that's true, and I believe that the study shores up the fact that that is true, then we have to do something about it. Not just because of the letter in which we've called out our need to do that, but because it's fundamental to the justice system that we examine what we're doing and improve it at every step of the way. The research from this groundbreaking study by the Gender and Justice Commission found that there are at least 16 areas in which they found gender matters in justice. And they came up with 5 overarching goals as a result of these categories. One is that we need to improve our data collection in every area of the law to ensure that we're collecting and distributing accurate, specific, disaggregated data that covers race, ethnicity, LGBTQ plus status in the criminal, civil, and juvenile areas of law that we cover. It recognizes a number of problems. We have a race problem in this nation. And one of the ways that manifests is just how we categorize each other. One example of that is what we do with people who are Latino, because under law, we're designated as white, although in society, we're certainly not uniformly treated that way. And race is a myth anyway, but we say this is an ethnicity, not a race, which further complicates the nomenclature, which results in a situation, for example, years back at the King County Jail, where they would say that the majority of the people detained in the jail are white, but that's because they counted Latinos as white. If you back Latinos out of that, the majority of people in King County Jail were people of color, despite them being about 16 to 20% of the population. So making sure that the data that we use is actually accurate and meaningful is a critical step that the Gender and Justice study recognized. The study also recommends that we improve access to our courts in every area of law that the report covers. And that means providing flexible hours to litigants. And it used to be, back when I was a trial court judge and suggested that we hold night court or weekend court, that the response was, well, that's not feasible because we'd have to hire security. We'd have to have the IT folks there. We'd have to have the HVAC system turned on for extra hours. And we can't afford that. We don't have a budget for it. What this pandemic experience has taught us is that we can hold court wherever we are, whenever we are. And we know that it's hard for people to get time off from work if they're working a 9-to-5 job. The transportation to our courthouses can be expensive. Parking for those who drive is very expensive. Childcare is expensive if it's even available. So I think it recognizes we need to be innovative in the way that we provide justice now. And perhaps we can do that after hours and on weekends, at least for certain kinds of hearings. We need to increase the help that we provide to people who are pro se and can't afford assistance. We need to make sure that we're using plain language and forms that are not overly complex so that people who don't have the benefit of assistance can fill them out themselves. We need to make sure that we're recognizing that some of the people who come before us, probably a large percentage, are experiencing or have experienced trauma in their lives, and be respectful of the emotion that they might exhibit, because all emotion, if sincere, is involuntary. The study recognizes that we have adverse effects from the increase in convictions that we've experienced over the last 2 generations in this nation. And we need to examine whether it makes sense and it's justified, whether we're getting the results of increased public safety, reduction of recidivism that we hope to get through our criminal justice system. And recognize that we have disproportionately affected through our justice system those who are Black or Indigenous or people of color or those who are gender nonconforming. The study recommends that we reduce our reliance on revenue that the court itself generates and make sure that we're advocating for general funds to be used to support justice, which is a function that inures to the benefit of all of us. What that means specifically, Austin, is reducing our reliance on user fees to support our courts, because that creates a perverse incentive for the court to fine people more, because that's how we pay our own salaries. We want to make sure that when we are making decisions and when we do educate our judges through our continuing judicial conferences and education, that we're doing it based on evidence-based information, on research. We're trying to take all of those steps through the administrative office of the court to respect the results of this very important groundbreaking study. And I want to reference Judge Marilyn Peja and my colleague, Justice Cheryl Gordon McLeod, the co-chairs of the Gender and Justice Commission, and the staff for the extraordinary work that they've done, that I think is going to help all of us come closer to the promise that we've made to each other.
And I can just put a punctuation mark on this by saying, just to quote from the press release here, the study's results were clear. Gender impacts access to courts and one's treatment within the justice system, and the adverse impacts of gender are most pronounced for Black, Indigenous, other women of color, and LGBTQ plus persons. Mr. Chief Justice, we do need to take a brief break. When we return, we'll continue our one-on-one interview with Chief Justice Stephen Gonzalez, back right after this.
Keep up on what's happening at the state capitol. Watch TVW, the legislature, Supreme Court, and executive branch. For the unedited gavel-to-gavel coverage of state government you won't find anywhere else, watch TVW.
And welcome back to Inside Olympia. Joining me once again is Chief Justice Stephen Gonzalez of the Washington State Supreme Court. You were talking about the gender and race study that just came out. There was also a recent report from a task force on race and justice that presented, and you've referenced this briefly at the end of September. Several findings, but help us understand the takeaway from your perspective of that particular report as well, and again, sort of the call to action for the judiciary of both of these reports.
Well, you know, the only way that the judicial branch functions is if people have faith that the process is fair. And it's clear that we have room for improvement in providing access and equity to everyone who appears. So the benefit of the Race and the Criminal Justice System Task Force and their report is that it's the product of all of the stakeholders in the system coming together to study. They're not going to agree on everything, but they're going to present to us their best analysis of where we are at this point in time and how close we are to our promise of justice for all. And to the extent that they're pointing out areas of concern where we need improvement, our job as the conveners, as the leaders of the judicial branch, is to task people with coming up with solutions for us. So it is the chance for the practitioner and the academic to come together, for defender and prosecutor, for civil litigant and civil defender, for advocates, for victims, and for those who have been convicted and need treatment, to come together and study how we're doing what we do, and to give us their best analysis of where we've fallen short. And it's incumbent upon us to be honest with ourselves and recognize that. I think sometimes we have a tendency to get defensive and to say, no, we're excellent, and here's all the things that we're doing. And while it's true that we've done a number of remarkable things, we're not done yet. It's a work yet in progress. And so I value very much that work and the report that they've presented to us. We need to study it carefully, and I await the recommendations that the task force is going to bring to us, again, within the next 4 to 6 months, so that we can evaluate those and take steps to improve what we need to improve. We've already done a great deal, for example, on legal financial obligations and the way that those are imposed, because we want to do things in a way that actually gets us results, that improves safety for everyone, and improves the faith in the justice system. Because as I've said, it only works if you believe that you've been treated fairly, win or lose, that you were heard and respected through the process.
I do want to mention that the Race and Justice Task Force was launched in 2020 following the issuance of that open letter from the Supreme Court. And it was the deans of Washington's 3 law schools that began this. And among the findings, again, just to quote, we come to you with deep concern, they said, about evidence we see of racial injustice in criminal law. At the end of the day, it's race, said Seattle University School of Law professor Robert Chang. So as you think about implementing recommendations, making change, obviously some of this comes with a price tag. Funding for the judiciary comes from the legislature. We have separation of powers. Traditionally, there isn't a lot of interaction between the two branches, but I know you've been thinking about and trying to engage more with legislators. 2021 was a very significant legislative session for the judiciary. How are you trying to reset or perhaps advance the relationship with the legislative branch, especially as you think about potentially the partnership that's going to be needed to enact some of this change if it's going to cost some money?
Yeah, I really welcome that question, Austin, about how the branches work together. And it's not just the two, it's all 3.
Sure, the executive as well, yeah.
And so we're trying to improve those communications while still respecting the separation of powers. And that's delicate because when you're in a room together, there's a tendency to say, well, what about this case that's coming up? And of course, we can't talk about that.
I'm trying to hold back on doing that too. Resist the urge.
Yeah. And I'll resist the urge to answer if you do ask me about a pending case, because I want to talk about it too, but there are rules that are in place for a reason. But there are areas where we can cooperate and should, where we can improve our communication, and we should. So at our Judicial Summit, which we hold every year, this past June, we invited representatives from the legislative and executive branches to join us at that summit as we explore the state of the judiciary and our priorities for the coming year. And we reached out, of course, to both sides of the aisle. So we had Republican and Democratic representatives from both the House and the Senate. We had representatives from the executive branch as well, who are involved in budgeting as well as execution of legislation that's passed by the legislative branch. And we talked about our priorities. We recognize that there are a number of things we need to focus on. One is our IT infrastructure and the coordination of that. We have recognized, and it was most poignantly brought to the forefront of our attention in the issue of protection orders. If a protection order is issued in a district or municipal court, can a superior court in another part of the state find it readily and know about it? What if there's a protection order in a federal case? Can our state system rapidly access that? And if the protection order has been dissolved, do we know that too, so that we don't try to enforce an order that no longer exists? And what about an order from a tribal court? Can the IT system that we have speak to that system as well, to that sovereign that may also issue orders that have effect in our jurisdiction? So that need is paramount. And the way that we fund our IT infrastructure is antiquated and it's not sustainable. So there needs to be a revenue source, and we don't get to decide that. And I sure hope we don't decide that we're just going to put a surcharge on the litigants, who are often indigent themselves, to try to pay for this system. So that's one clear area that we've identified that we need to work together on, because budgeting is something we can talk about without violating the separation of powers. Another area that's come to the fore is security. And it's not just security for the judicial officers, but for the litigants. We order people on penalty of a criminal penalty to come to court. If we do order people to come before us that way, we have to make sure that while they're here, they're safe. And we're not doing enough to ensure that. And that's a statewide obligation. It's a funding issue, and it's both the operating budget and the capital budget that's affected by that. And those have two different processes, and both need to be addressed. We also have a real problem with a looming eviction crisis. We're going to have, now that the moratoria are expiring in some areas, we're going to have more of those filings. And landlords and tenants need help. Fortunately, and I think you'll hear more about this when you talk to our Office of Civil Legal Aid and our Office of Public Defense, that we have a new pilot program, the Eviction Resolution Pilot Program, which has our dispute resolution centers stepping up throughout the state to help moderate, mediate, and find solutions for landlords and tenants. There is some funding available to help both sides, and there are ways to make the process more humane. And so I'm very hopeful and optimistic about those steps that we're taking. So I look forward to the continued communication among all three branches of government, and we've all committed to redouble those efforts to make sure that we communicate while respecting our different roles.
How would you characterize the 2021 session, which of course was unique and unprecedented in and of itself, because it was done mostly remotely? There was a lot of federal money, though, that came to the state in the form of COVID relief dollars. Oftentimes, we will see the State of the Judiciary speech before a joint session of the legislature. That's tradition, of course, not in the midst of COVID. And then the judiciary doesn't get a lot of attention, but it seems like there was sort of a confluence of events and perhaps the arrival of some of this federal money that allowed for investments in the judiciary, not to mention policy changes that directly affect people in the court system, that was really remarkable, if not historic.
What I'll say about the last session is that I want to congratulate the legislative and executive branches for, under very difficult circumstances, working through tremendous challenges. I have deep respect for the work that they have to do, reaching across the aisle to address eviction, security, safety, and grapple with very difficult policy choices. And that's where policy should best reside. That's in the legislative branch as they pass the laws. And doing that remotely is tough. I mean, you and I are talking to each other right now on a video screen. I would much rather be at a desk next to you, chatting and having a face-to-face discussion. We're doing the best we can with where we are right now. And I think the legislature did the same thing in the last session. I know that these times are unprecedented. Fortunately, there does seem to be a surplus right now, which is interesting when you look at the problems that some members of our society are having. This surplus isn't affecting all of us equally. And addressing that and making sure that we're just in how we move forward and spend money resides with the legislative and executive branches. And I just want to say I am impressed with how they were able to get their work done and done on time under difficult circumstances.
As you look ahead to the 2022 session, and I know you've highlighted court security as a key and top issue, I believe that the current budget funded about $750,000 in trial court security improvements, but I expect that that's not enough to address all the problems. But what are you thinking about in terms of priorities for 2022?
Yeah, it sounds like a lot of money, and I guess it is, except when you consider the number of courts we have statewide. That's the amount that might help, if we really spent it, a couple of municipal courts. It wouldn't address the problems statewide. So the investment is larger than that. It needs to be a serious investment and commitment. So there's more work to do on security. The courts of appeal and Supreme Court also could stand to improve our infrastructure and our security, but it's especially acute at the trial courts. And I'm sure you've recognized this, and the studies show it, that we have exhausted a lot of our reserves of patience and civility. People are mad faster. They're reacting more angrily. I think we've seen an increase in violent crime, and that emotion and that anger can bubble over in courthouses. So we need to make sure that we continue to provide a safe and secure environment for people to resolve those disputes that they're unable to resolve without the assistance of the court system. We're here for those instances when people are so far apart that they can't resolve them without intervention. We are that intervention, and we need to make sure we can do that in a safe environment.
Regarding the 2022 session, besides additional funding for courthouse security, any other top asks or considerations at this point?
Well, we also, as I mentioned before, have a need for our IT infrastructure to be improved. Court education is always important, but it's the technology and the security and some additional funds to make sure that we're competitive as we pay our staff. Those are the three things that we're really pushing for in this session.
You have alluded to this, but I do want to ask you how COVID has been disruptive. It has certainly slowed the trial courts. So I have two questions in mind, and I'll ask them both at the same time. Trials slowed down. What do you think is going to happen? What's the lasting impact of that? And then how will COVID have changed the way we do court? Does this open up some options for access to justice remotely?
Well, I want to say one thing first, and that is that the result has not been uniform across the state. It varies greatly. Some courts are not behind at all with the ability to hear things remotely. Some courts have kept up completely and aren't behind at all. At the appellate court, we're not behind either. There has been a bit of a reduction in some of the filings, and we've also been able to get our opinions out. And for my court, we're not behind at all. So it's not the same result. There are certainly courts that are significantly behind, but it's not uniform. King County at one point had dozens of murder cases waiting to go out that couldn't go out. I mentioned before there's going to be, I think, a wave of eviction cases coming. So we will get slammed as a court because of this, but we're not uniformly slammed. It's very different court to court. So it's important for us to be sensitive to those differences and make sure that we're using our resources to bring us all up to the point where we can provide access to justice in a timely manner. And in some ways, it's not the same between civil and criminal either. The civil side has been much more likely to embrace remote jury trials. And so they've been able to move forward more effectively than some criminal cases have. But one of the silver linings from the pandemic is that we have begun communicating more within the judicial branch itself. Justice Stevens began a process of meeting regularly with the presiding judges from across the state, and I've continued that process where we're discussing what we're all facing and comparing notes and finding solutions together. We have learned that some of our processes needed to be updated, and pandemic has forced us to do that. We have found that there are ways to provide interpreters remotely better. We recognize that remote interpretation is not the standard, it's not the ideal, it is a backup, but necessity has required us to improve that technology in the way we do that. So we've formed a court recovery task force, which has evaluated how we're doing during the pandemic, made recommendations during the pandemic, and is making recommendations for those things that we've learned that we can carry forward after the pandemic as well. And so I'm very proud of my judicial colleagues across the state who have put in a tremendous amount of extra hours to try to make sure that we're meeting our goal of access to justice.
I want to ask you, we just have a few minutes left, about the Redistricting Commission, which has a November 15th deadline to come up with new legislative and congressional maps. Historically, they've met their deadline and found agreement on this bipartisan commission, but if they don't, it gets tossed to the Supreme Court. Are you prepared for that possibility, eventuality, and how would that work? Do you have some map makers on standby?
Austin, you're asking about a case that may come to us and what we'll do with it. We will do everything we can to meet our obligations. I am not a map drawer. We will need to rely on someone with that expertise. We don't want me with crayons trying to draw maps. We need somebody who knows what they're doing. But if it comes to us, if we have to step in, of course, we will do our best to do it right.
Do you feel at liberty to speak about the Blake decision, since that has been decided, the case that found unconstitutional the state's simple drug possession law?
Yes, and it depends.
Okay.
So please go ahead with your question.
Well, I'm wondering, I mean, that's a significant case that has then resulted in a change in state law, and there will be more changes to state law as a result, undoubtedly, because of that. But I guess the question is, what precipitated that, or as you looked at that law, how are you thinking about the impact of finding it to be unconstitutional and the sort of historic moment that represents, especially when you're talking about equity?
Well, describing that case for the viewers who might not know about it, it was a challenge to the statute that criminalized simple possession of controlled substances and did not require the state to prove that the person who possessed them knew that they had them, which is described as a strict liability crime. So Austin, if you were handed a package by me and I said, please give this to your producer, and you did so, and if that package contained a controlled substance, you could be charged and convicted if the jury found that you possessed that package. It didn't matter that you didn't know what was in it. And previously, when that same statute had been challenged before the Supreme Court, our court had said, that's a problem, but what we're going to do to try to fix it and find it constitutional is say that the defendant can assert an affirmative defense of unwitting possession. And if they can prove that they didn't know they had it, then they're not guilty. Well, that's not how it works. I appreciate our effort to try to save a statute passed by the legislative branch, but I think that was too much deference. And we shouldn't have done that. We should have just said, I'm sorry, that's not constitutional. So what we did was revisit that precedent. And it's an example of finding that our own attempt to fix that deficient statute was incorrect and harmful.
Well, and with less than 2 minutes to go, let me just ask you, this has opened up a bigger conversation in the legislature and in the state about drug laws. Is that, I realize that wasn't your intent necessarily, but are you happy to see that? Do you feel like that's a positive result of this decision, which was, again, based on the particular statute?
Well, that's where that policy decision should be. So that's the appropriate place for that discussion to happen. I know it's not an easy discussion. The solutions aren't readily apparent to anyone. And I congratulate them for engaging in it.
With about a minute left, less than a minute, a closing statement from you.
I'm optimistic about our judicial branch and about our future. I'm pleased with the court that we have. We have a diverse court, and what we find is that it doesn't necessarily make us more efficient, but I think it means that our discussions are deeper, they're richer, and I hope we come up with just decisions as a result. And I look forward to continuing to serve along with my colleagues, and I appreciate this chance to talk to you, Austin. about our branch of government.
And when you say you're optimistic, because there are so many challenges facing this state and this country, again, just very briefly, why are you optimistic?
I'm optimistic because I know the hearts and minds of my colleagues, and not just those here at the Supreme Court, but judges across the state. I see the goodwill and the effort that they're putting in through our meetings. I know how earnest they are to improve access to justice and the outcomes themselves. I'm optimistic that we're going to continue to improve. And frankly, Austin, I think optimism is our only choice. Despair to me is unattractive.
Chief Justice Stephen Gonzalez, thank you so much for joining us. I appreciate it very much. You also previewed an upcoming episode where we will be talking to the Office of Civil Legal Aid and also talking about public defense in the state, so stay tuned for that. Thank you for watching Inside Olympia. We'll see you again next week.